Hey everybody, Brett Thompson here with Thompson Law Group, another Teaching Tuesday. We are starting our North Carolina Teaching Tuesdays, all right? So we're gonna start to address North Carolina specific transactions. So we're gonna do two different lanes. We're gonna have Virginia and North Carolina. And I'm also gonna talk about the distinctions between the two different states. Today I wanna talk about North Carolina law as it pertains to married couples acquiring real estate. In Virginia, you have to spell out how the couples are going to hold title in the granting clause. And the most common three ways to hold title for married couples is either tenants by the entirety with the right of survivorship as a common law, or joint tenants with the right of survivorship, or tenants in common. In Virginia, if you just named in the deed Bob and Mary Sue, okay, and nothing else, by default, they would be tenants in common, meaning that they would each own an undivided 1/2 interest in the property. And if the husband got hit by a bus, his interest would pass to whoever his heirs were in his will or by intestate succession, all right? It would not automatically go to the wife. Or you could choose joint tenants with the right of survivorship. And in that event, if the husband got hit by a bus, by operation of law in Virginia, his interest would pass to his wife, his widow. The preferred method for married couples to hold real estate in Virginia is tenants by the entirety with the right of survivorship. And it has to be spelled out in the deed. So it has to be Bob Smith and Betty Smith, husband and wife, tenants by the entirety with the right of survivorship. That's the most advantageous way to hold property because there's different benefits for the marital home. The main benefit is creditor rights or shielding from creditors. So for example, if a married couple owned property, tenants by the entirety, and one spouse got a judgment against them, all right? So let's say one spouse either had medical bills or they didn't pay their credit card and they got sued and a judgment was entered against, let's say, the husband. Well, that judgment would not attach as a lien to the marital home. So if you own property tenants by the entirety, you have to have a judgment against both the husband and the wife. And at that point, it would attach as a lien to the marital home. So let's jump over to North Carolina. North Carolina does it a little differently. If a married couple is acquiring property in their individual names, by default, under the law in North Carolina, they will hold title as tenants by the entirety with the right of survivorship. So you don't even have to indicate that they're married. If in fact they are a married couple and they're the named grantees in the deed, meaning that you've got the grantor who's the seller and the grantees who are the buyers. So if it says we hereby grant and convey to Bob Smith and Mary Smith, preferably it would say husband and wife, or it would indicate in some fashion that they're married. But under North Carolina law, that's not a requirement. And if they in fact are a married couple, by default, without any other language in the deed, they will be tenants by the entirety with the right of survivorship. Therefore, they will have the benefits of tenants by the entirety, which the main benefit is the creditor protection. So if either one spouse were to get a judgment against them, it would not attach to the marital home held by tenants by the entirety. So interesting distinction, important distinction between Virginia and North Carolina. And this is our official first Teaching Tuesday for North Carolina law. Hope you enjoyed. Thanks a lot.